What is a trademark? A trademark is an intellectual property right granted by a government to an individual, business, or legal entity that creates and uses a distinctive word, name, symbol, or device to distinguish its products or services from those of any other entity in the marketplace. The original purpose of a trademark was to indicate the origin of goods and services. Trademarks protected the public by preventing mistakes, confusion, or deception by those who would palm off their goods as those of another. But it also served to protect the market and reputation of the producers of goods. As modern markets evolved, trademarks also developed into guarantees of quality as well as potent marketing and advertising devices. Trademarks as branding. Consider, for example, the role that Nike's swoosh logo plays in its $106 billion shoe, equipment, and apparel business. In 1971, Nike founder Phil Knight paid graphic design student Carolyn Davidson a mere $35 to design the swoosh logo for the fledgling new company. According to the Portland Oregonian newspaper, when Knight saw her design, he reportedly told her, "I don't love it, but maybe it will grow on me." Nike attorneys nonetheless registered the logo with the U.S. Patent and Trademark Office on June 18, 1971. Today, this one logo is estimated to be worth as much as $20 billion and is recognized around the world as a symbol of Nike's quality workmanship and design. Indeed, its vital role in protecting Nike's market share and reputation explains why the company so strenuously protects its trademark rights from being infringed by counterfeiters. As for Carolyn Davidson, Phil Knight gave her Nike stock in 1983 that is today worth more than $850,000. How are trademarks different from patents and copyrights? Trademarks versus other intellectual property rights. Trademarks share with other intellectual property rights the power to encourage and reward creative enterprise. Trademarks also share with patent rights and copyrights the public policy goal of marshaling the benefits of created endeavor, in this case, the distinctive branding of one's products and services from those of others to the public good. They do this by protecting consumers from deception and encouraging sellers to provide quality products. But trademarks are different from other intellectual property rights in three key respects: Congress and trademarks. First, although the Constitution grants Congress the right to legislate on patent and copyright, it does not expressly grant Congress the right to make trademark law. The legal foundation for trademark law lies in the Commerce Clause of the Constitution, which gives Congress the authority to regulate interstate commerce and enact whatever necessary and proper legislation is required to do that. Second, trademarks are different from other intellectual property rights in that they are not limited in duration. Patents and copyright are granted only for limited periods of time because society benefits by putting an invention or literary work into the public domain once the inventor or artistic creator has recouped his or her costs of innovation and been awarded for his or her pioneering endeavor. Trademarks, however, never hinder the sales of other products or services, so they are granted in perpetuity so as long as they are not abandoned by the trademark owner. Trademarks mean business. And finally, trademarks exist only in conjunction with commercial activity. An inventor may receive a patent for a new invention and never employ or practice that invention in a business or research endeavor. Similarly, an author can receive a copyright for an original literary or artistic work and yet never publish, display, or sell it. A trademark, however, cannot exist by itself, separate from commercial activity. Thus, a trademark cannot be obtained by mere adoption. It can only be acquired through commercial use or in anticipation thereof, for example, through the sale of goods and services.